Hello, thank you for joining us on Code Files on Third Eye Africa TV from the nation's capital here in Abuja. Cases have lingered in courts in Nigeria, and that is why we are here on this program to look at some of those cases that have lingered endlessly, prolonged trials, and sometimes, if you like, abandoned trials in our courts. And you might want to recall that several individuals, politicians, have been accused of corrupt practices in the past. And some of them serving governors, some of them past governors, some of them serving senators. And some of those cases, you would say, kind of have been forgotten or even abandoned, or the least we've heard of it is kind of no longer in existence. So this raises the question of how fair is the fight against corruption in Nigeria, of course, with individuals that names we might not be able to mention in a singular episode. But we know a lot of politicians who allegedly were fingered in corrupt practices in the past. And some we call it media trial, some we call it name it. We can call it different names. But the list we heard is, okay, they've been arrested by the EFCC, ICPC invited them and all of that. But the case becomes a cold case file. And that is why we have this program to, refresh our minds on cases upon cases that we've had in the judicial sector that were, unresolved, that were left unresolved. And we have numerous cases. And as we proceed on this program, we'll continue to bring some of those cases to the front burner in order to remind the concerned prosecution agencies, of course, the judiciary, that our eyes is on the ball as Third Eye Africa TV. And that is what we do, a crime watch channel that is focused on crime prevention, investigative reporting, and of course, community safety. This is the program Code Files, and my name is Charles Agedu. Today on the program, I have a guest with me in the studio, but I'm not just going to let the cat out of the bag yet. I would just take a pause here, give you a short prologue of what we kind of set the pace on the program today in terms of the topic, the main topic that we'll be focusing on today when it comes to one of the numerous prolonged trials in the courts today. So please just don't go anywhere. Just stick around. I'll be back just in a moment to introduce my guest and, of course, delve straight into the topic of today.
FILES Kyari, the suspended Deputy Commissioner of Police and former head of the Police Intelligence Response Team, IRT, faces charges from the National Drug Law Enforcement Agency, NDLEA, for drug trafficking, conspiracy, obstruction of justice, and cocaine dealing. Additionally, he is wanted in the United States for a separate fraud case involving Ramon Hushpuppi Abbas. The NDLEA alleges that FILES Kyari was part of a drug cartel that operated the Brazil-Ethiopia-Nigeria illicit drug pipeline. According to the agency, Kyari contracted one of its officers in Abuja to negotiate the release of 25 kg of seized cocaine. He allegedly offered a $61,400 bribe, equivalent to 35 million as at that time, to NDLEA officers who cooperated with the investigation until his arrest. Nigerian police had been investigating Kyari for over 8 months after the United States Federal Bureau of Investigation (FBI) indicted him in 2023 for his alleged role in a $1 million scam involving international internet fraudster Ramon Hushpuppi Abbas and 5 others. The FBI reported that Hushpuppi paid Kyari 8 million naira, about $20,600, to arrest and detain a co-conspirator, Chibuzo Vincent. Although the United States Attorney's Office for the Central District of California declared Kyari wanted, the Nigerian government has not extradited him to face prosecution in the US. This development occurred before Kyari's current ordeal with the NDLEA. Kyari was arrested by the police and handed over to the NDLEA in February 2022 after he failed to honor an invitation for questioning. He was arraigned in March 2022 along with 4 other police officers. All of them pleaded not guilty to the charges. After several initial bail denials, Abba Kyari was eventually granted conditional bail in July 2022 on a separate charges related to asset declaration. He was released from the Kuje Correctional Center upon meeting the bail conditions. However, his main trial on drug trafficking charges is still ongoing. The Nigerian government approved the US request to Abba Kyari's extradition in connection with the hush puppy fraud case. However, the ongoing drug trial against Kyari in Nigeria has taken precedence, delaying the extradition process.
Welcome back from that quick break, and I think that has set the tone for our conversation today. Like I said at the beginning of my introduction, I am not going to be doing this alone today, as I have a learned friend with me in the studio, a legal practitioner, Sunday Iyanu Okpola Esquire, who is a legal practitioner has joined me today on the program to take a look at one of these numerous unresolved cases in the judiciary. And if you had followed the program from the beginning and followed me from the prologue, I think it's not going to be new to you as to the main topic that we'll be talking about today, a case involving a former deputy commissioner of police in the person of Abba Kyari, who his case is one of the numerous endless cases we have had in the judiciary. To date, I think the case we've just received a date for judgment in this new year, that February 26th, so to speak, that will be the day the court has fixed for judgment. But the case has been on, since 2022. Mr. Sunday, you are welcome to the program.
Thank you very much, sir. It's great having you here.
I want to sincerely thank you for finding time, irrespective of your ever busy schedule, to join me on the program today.
Thank you very much.
Yes.
I'm pleased to be here.
I thank you so much. And during my prologue, you'll see that I began the prologue with the case involving the former head of the IRT, Intelligent Response Squad of the police, in the person of Abba Kyari.
Yes.
And that case has been on since 2022.
Exactly.
And this is how many years down the line? About 4 years down the line.
Going to 4 years now.
Going to 4 years now. Yes. So this is not the only case that has lingered. We have cases since 2015, and some I don't want to use. I'm carefully using my words here because I sometimes I'm tempted to say abandoned. Do you think cases that drag for this long, do you think is a good one in the fight against corruption in Nigeria?
Yes, thank you very much. When it comes to the criminal procedure, as we have it in Nigeria, and particularly looking at the Abba Kyari's case, he was arrested in 2022, and he was charged in 2022. And if we all could remember, walk down memory lane, we know that currently they have two different charges against Abba Kyari at the Federal High Court.
Yeah.
We have one pending before Honorable Justice Iwite, and the other pending before Honorable Justice Omotosho.
Absolutely.
So I'm going to start with the one pending before Honorable Justice Omotosho.
Okay.
That is the one that was filed by the NDLEA.
Okay.
The charges including the lack of asset declaration.
Okay.
That's the asset declaration case before Honorable Justice Omotosho.
The one that involved him and his two brothers.
Yes. Where it was alleged that they did not comply with the laws provided for asset declaration for public officers.
Okay.
And being charged in 2022, they came with about a 23-count charge in that matter, pending before Honorable Justice Iwiti of the Federal High Court, and it was charged under, I think, Section 35, Sub A of the NDLEA Act, and also it was charged under Section 15, Sub 3A of the Money Laundering and Prohibition Act of 2011. Now, if we look at that case, the prosecution, after the charge, several bail attempts were made, and he was finally granted bail, and the prosecution opened their case. I'm just trying to give a step-to-step
Yes,
procedure.
an overview, yeah.
The prosecution opened their case, and they brought in as many as, I think they brought about 10 witnesses or more, and a lot of evidences were admitted by the court. And after the end of the prosecution's case, after they closed their case, the defense, rather than enter into a defense, brought in a no-case submission. They applied for a no-case submission. What they are saying in the no-case submission, in essence, is that the prosecution have no case.
Okay.
That with all the material evidences and fact that they've placed before the courts in opening their case, that the defense do not have a case to answer. That is what the no-case submission actually means.
Okay.
And the no-case submission application was taken and heard by both parties, by the court, from both parties. And the Honorable Court then entered into a ruling dismissing the no-case submission. Dismissing on the ground that, yes, the defendants have a question of doubt that needs to be cleared, that needs to be answered. And the defense entered into their defense naturally. And what is their defense? Naturally, yes, he declared his asset according to the law, which is their defense.
Okay.
And after that, closing argument, and the case has just been adjourned for judgment, I think February 26th of 2026. So I think looking back from when the charge was filed 2022 to now, you went all further to ask why it took this long, and if cases normally take this long. The thing is,
I want to also add to it that what do you think is responsible, that is responsible for many of these slow trials in our courts? That is, it's also part of the question.
Okay.
Not just peculiar to Abba Kyari's case.
Okay. Before I come down to the peculiarity of Abba Kyari's case, I think let me just quickly answer that question. Why do cases last so long in our courts? There are so many factors. Let's just be honest to ourselves. There are so many factors. The judges, the courts, are sometimes overwhelmed with a lot of cases. There are a lot of cases before the courts. And in each peculiar case, in a day, a judge can sit over probably 12, 15 cases in a day on the course list. And every case needs to be heard. There are criminal cases that can take up to 3 hours in a particular day. Now, if you take 3 hours looking at a course list of probably 15 cases in a day, do you honestly believe that from 9 a.m. when the court sits to whenever the court rises, they will have done substantial justice to those 15 cases in that particular day?
Okay.
Now, according to the Administration of Criminal Justice Act, in which we are currently practicing, criminal matters are supposed to be on a daily trial, a daily thing. But that is not feasible because there are so many factors that comes with case proceedings. Let's say the human factor, for instance. The judge can get sick. The judge is also a human being. And when he gets sick, doesn't sit on that particular day, the case cannot go on. You have to pick another date. The prosecution can also get sick. The defendant himself can also get sick. Even we as defense counsels, we get sick, and we also we inform the court about this development, and we take another date. You can't expect a sick person to come to court and try and take on the tediousness that has to do with criminal proceedings. That's one factor. Second factor, the prosecution, like in Abba Kyari's case, sorry, I'll be just going pari passu with Abba
Go
Kyari's
ahead,
case.
please.
They called over 10 witnesses. Those are 10 different persons.
Okay.
You can't hear 10 different persons in a day. Why? Because there are other cases on the cost list. Other lawyers also want to have a bite at the cherry, like we all say, also want to have their time in court. So now, if a prosecution comes with 10 witnesses, you hear one, the cross-examine. A witness can take up to the entire 3 hours that we're talking about, because in cross-examination, you ask as much question just to punch the story of, or the alleged crime
Okay.
as alleged by the prosecution, yes? Now, they have 10 witnesses. Let's be honest with ourselves. Do you think you can take 10 witnesses in a week? Looking at how cumbersome our courts are with so many cases. So many cases. There are so many cases in our courts. As I'm talking to you right now, there may be a lawyer sitting down somewhere drafting another case right now,
Okay.
ready to be filed.
Okay.
You understand? And our agencies are really, I would say they're trying their best, because with the kind of illicit practices that goes on in the country, and them trying to make sure every one of them is being answered for, I think they are also being overwhelmed. They are also being overwhelmed. And that also can cause delay. A witness that you have might not be around, might travel, witness may die, witness may also get sick. All these amount to 1 or 2 delays in a particular case. Looking at the Abba Kyari's case, I think the witnesses that the prosecution called took about a while, because some of them were not available as at the time that they were being called upon. Secondly, the court may not sit, because another factor is this: the judges can also be away on judicial activities, official duties, and they may not sit on that particular day that the case is adjourned to. For instance, the case might be adjourned to maybe 2 weeks from now, or maybe 3 weeks, a month from now.
Okay.
And on that particular day, or during that week, that judge is being called on official assignment. He has to answer the official assignment. The judge goes away for the official assignment. That case cannot go on, because there's no judge to sit over your case. Even if the prosecution is there, the defense is there, and the defense counsel are there.
Okay, so I'm not just going to be asking you let's take a look at the second case aside this one.
That's the one pending before Justice Nwite.
Yes.
Okay.
Yeah, I'd also like us to just quickly establish that, so that I can post the question that I'm going to ask you that will answer the two of them side by side. Because I know you might also be pointing at the same challenges before. So just throw a light on that.
All right, that's the case pending before Honorable Justice Nwite.
Yes, please.
That's the one that the NDLA charged Abba Kyari and I think about 5 others or so, and for tampering with evidence and I think collection of bribe of $61,400.
Yeah.
Yes, that case is pending before Honorable Justice Nwite. They were charged in 2022, and some of the defendants in that particular trial pleaded guilty.
Absolutely.
And I think they went for a plea bargain, and they were sentenced to 2 years imprisonment.
Okay.
And Kyari and his 2 sons, I think, and 2 others actually, did not plead guilty. They pleaded not guilty.
Yeah, I think the Kyari and 2 sons had to do with the one that has to do with asset declaration. Then this other, the one that has to do with the cocaine and everything has to do with some other police officers.
With his colleagues?
Yeah, with his colleagues.
Yes, some of them pleaded not guilty together with Abba Kyari.
With Abba Kyari.
Yes, and then the prosecution also entered their own case. They opened their case,
okay,
and they brought in their witnesses, they brought in evidences before the court, and at the close of their case, the defense also brought in the no case submission that the prosecution have no case. And so the defense do not have to enter their defense because the prosecution has not established a prima facie evidence before the court. And I think the ruling was delivered just of recent by Honorable Justice Nwite, dismissing the no case submission and ordering the defendants to enter into their defense.
Okay, now, if the other parties that were involved in this same case,
yes,
pleaded guilty,
yes,
I know in law,
yes,
there's there's precedence,
Yes.
right?
Yes.
If a case is established,
Yes.
you don't need to go over the trial again.
Yes.
So if these people that were part of that same accusation pleaded
Yes.
guilty, and there are evidence that Kyari's name was mentioned in their trial,
Yes.
so why is it so difficult to apply that to this same trial?
In this particular trial, the ones that pleaded guilty only pleaded guilty as to their role in the allegation.
Okay.
As to their role in the allegation.
In the allegation involving Kyari and others.
Yes. As to their role in the allegation, they pleaded guilty to that, to the extent of that, and they were tried on that, convicted, and sentenced on that. But Abba Kyari felt, oh no, I've done nothing wrong. I didn't tamper with evidence. I didn't remove evidence. I didn't move evidence. I didn't collect money.
I didn't offer bribe.
I did not do all those things.
But
that
there's
they
a
charged me
video.
for.
There's a video of him and the NDLE official in the car, with a conversation over the dollars that was being offered.
Yes.
And the NDLE official, cooperated and took that as evidence. So the question I'm asking is, why is it difficult for our courts, to, admit clear evidence that is in the media, that is available online, and the accused person is there?
Mm-hmm.
So why is it a deliberate attempt to slow down the wheel of justice when we have so much evidence, and at the same time, why is this still dragging and taking this long? To somebody with that kind of evidence still, saying you don't have no case?
Well, the law is that you are innocent until proven otherwise.
Absolutely.
That is the law.
Okay.
And there are processes and procedure, like I said earlier, that needs to be followed, that needs to be observed before a case can go on, or during the pendency of a particular suit.
Okay.
Otherwise, your suit will be thrown away on appeal.
Okay.
So, yes, the society might say, oh, the justice system is so slow, the justice system is taking forever to... We are seeing audio evidence, there's a tape leaked everywhere, it's all over social media. But do you know that there are processes and things that needed to be done before those things are even accepted by the court? If those things are not done, and they are brought to court, we can raise defenses as to their admissibility in court. Yes, there's a video evidence that everybody can see. Mm-hmm. But the question is, according to the law, is that video evidence even admissible? That is the question of the law.
Okay, let me ask you, is it admissible or not?
Well, I wouldn't want to dive into that because I am not a judge.
Okay.
And the matter is least pending, is still pending before the court. So I wouldn't want to dive into that. But then, like I said, for you to be able to bring such evidences or any evidence for that matter to court, you have to go through some set of rules. We have our High Court rules, we have our Federal High Court rules, we have the Administration of Criminal Justice Act that guide our criminal proceedings, that guide how we do things. So if all these processes are not adequately observed, you will say that, oh, they've bottled the case, they've sold this one, they've sold that one, and the person is maybe the prosecution rushes over their case because they are under the pressure of the entire society saying, oh, this case is taking longer than expected. You are supposed to do your job to the best of your ability, both from the prosecution side and on the defense side. Now, for you to be able to do your job to the best of your ability, you should be able to exhaust all possible scenarios. You should be able to exhaust all possible, look at the rules, look at the laws, the ones that favor you, the ones that don't. And you should also, and they're also trying to ensure that they do not negate the processes as required by our rules. Because when you do that, and I go on appeal, it's a ground on appeal.
Okay, now talking about the rules, I want us to look at the prosecuting agencies.
Yes.
For example, whether the EFCC, the ICPC, the DSS.
Yes.
Do you think they don't kind of do due diligence or enough investigation or gather enough evidence, including the NDLA in this case of Kyari, before charging suspects to court? Could that be responsible for some of these rules that you just talked about?
Before a suspect is being charged to court, before a charge is being preferred against a suspect, I believe the prosecuting agencies must have done their due diligence. They have done their investigation. It is at the end of the investigation, they've gathered enough evidence.
So why is it so difficult? That
investigation that they now said, no, look, with this evidence that we have, we are supposed to charge this person to court.
Okay.
And they charge the person to court. Now, the evidence is gathered during their investigation is being brought to court. But before it's being admitted in court, there are processes that need to be observed. There are things that need to be done.
Okay, can you just take us through some of those processes?
Well, it has to do with Evidence Act of 2011, admissibility of either documentary evidence or evidence in general. There are things that you need to do. Maybe if you are bringing probably a photocopy or an original
or a video evidence,
whatever evidence, there are certain things that the Evidence Act provides for that you must do. Before all these evidences are being admitted or accepted by the court. Now, for instance, let's say I want to admit a document, and probably the document is a photocopy. The question is, where is the original?
Okay.
Now, I have to, as if I'm a prosecuting agency, I have to lay grounds and foundations as to where the original is. Okay. If I don't do that, that document may probably not be accepted into evidence.
Okay.
And that document may be as important to my case as it is important for the defense for that document not to be admitted. So you see, the prosecuting agencies need to vet their investigation. They need to dot their I's and cross their T's before going to court.
Okay.
And when they've gotten to court, definitely it is not the lawyers that does the investigations. They have investigating officers that do that.
Okay.
And then the prosecution departments of these agencies then come to court with the evidences gathered. They are the ones that know the procedures and the protocols that they need to follow before all these things have been admitted. They are the ones that ensure that these are the do's and don'ts to help our case. Now you see, going through all that, time has to be expelled. Time had elapsed. Time is going because time waits for no one, obviously.
Okay.
So in as much as you are trying to gather evidence and get your stories, your facts right, your facts checked, your I's dotted, your T's crossed, you have taken some time.
Okay.
And like I said, aside that, there are other factors that delay matters in court.
Okay.
But then I want the entire public to know that it may be delayed. Justice is never denied.
In some cases, they say justice delayed, justice denied. But let me just hold your thoughts there. And this conversation is getting interesting. But at this point, I would like us to just take a pause and take a quick break. And after that break, we'll come back and look at public perception about the judiciary. Yeah, you know, there's this public perception. There's this, belief that justice delayed is justice denied. And we've seen so many cases that were assumed to be abandoned or forgotten totally, involving bigwigs, big politicians, former governors, former senators or present senators, party leaders and so on. And I would like us to, do a quick, review and look at the public perception about the judiciary when we come back from this break. In the last 20 minutes or thereabouts, I've been in the studio with a learned friend of mine here, a legal expert, Sunday Yanu Okbola, who is a legal practitioner. And if you have missed this first half of the program, please don't miss this remaining half, because it's been an interesting conversation with him, throwing lights on reasons why cases prolong in our courts. And this is your program, Code Files, on Third Eye Africa TV, where we do overview of cases, lingering cases in our court. Of course, look at where the like they say in the local parlance, where the water might be passing on under the bridges. Look at the two sides of the coin, and of course, there is the third side of the coin, which is the edges, to possibly, throw more light on reasons why cases are prolonged or delayed or even abandoned, assumed abandoned in our courts. And
okay, that's an interesting way of putting it.
So please don't go away. If you have just joined us, this is Third Eye Africa TV, your #1 crime watch channel in Africa. We'll be back after this quick break to continue the conversation.
I report. Have you ever witnessed a crime or suspicious activity around you? Don't stay silent. Take action. You can now report crimes easily by sending videos to us on iReport. Record a video and a brief narration of the incident with the location and send to 0701 372 8007 on WhatsApp only. Your action could help save a life or stop a crime in progress. Stay alert, stay safe, be the voice, take a stand. I report only on Third Eye Africa.
Welcome back from that break. If you have just joined us, this is Code Files on Third Eye Africa TV. In the last 20 minutes or thereabouts, we've been trying to do an overview of one of the many cases in our courts today, which is the case involving the former head of intelligence response team, which is the IRT, talking about Abba Kyari and others. And my very good friend here, Sunday Iyanu Okpola, who is a legal practitioner, has joined me to, do an overview of that particular case, and of course to look at numerous challenges before the court, reasons why cases drag endlessly in the courts. And Sunday, I want to thank you for your time again.
Thank you very much for
It's been an interesting conversation with you.
Really
Now, let's quickly move to public perception about the judiciary. What I mean by public perception, a lot of people have this notion that justice delayed is somehow justice denied, and you might want to partially agree with that, because some of the cases that I think assumed forgotten, which is involving bigwigs like former party leaders, former governors, senators, name it. I don't want to start calling names, but I have endless names of these cases that I assumed have been forgotten, left unresolved, abandoned, if you like, forgotten by even the members of the public or even the people involved in those cases. What, as a legal expert and a professional, what would you say is the biggest challenge with these cases that we have mentioned? We're focusing on Abba Kyari, quite all right, but there are cases that have dragged longer than Abba Kyari cases, and the public perception is that the judiciary, in connivance allegedly with the executive, deliberately, slow down the wheel of justice in some cases, or leave it unattended to, or even completely abandoned. Like, if I follow up with what you explained, like a judge might be sick, you might have several reasons and I've been to court in some cases, okay, and a judge is just absent. Not that the judge is sick. Sometimes they are just not available, and sometimes the judge is available. The judicial workers you might call for a case, and the file is not even available in the list, and so numerous cases, and we've had issues with getting to court, and cases are just not entertained. What, as a professional, would you say is one of the biggest challenges, one of the numerous challenges we have? There are numerous challenges. Yes. Which would you think is the biggest among these challenges that we have today? Do you think there are no selective trials in terms of corruption trials in Nigeria today?
Well, when you say selective trials, I wouldn't want to think so, because when it comes to trial starts at the point of where a charge is being filed. Trial starts at the point where a defendant is being put in the dock and asked to take his plea. The charge is being read to him, and if he understands, yes, is he guilty or not guilty? No, I'm not guilty. Yes, I'm guilty.
And they are granted bail.
That is where the trial
and
starts.
it ends there in so many of these cases I have mentioned.
I understand. There's a public perception as to the fact that some people perceive bail of defendants to be a slap on the wrist. Everybody is entitled to bail. It's a constitutional guarantee. When you look at Section 36 of the 1999 Constitution, you look at the Administration of Criminal Justice Act, bail is a constitutional guarantee. Everybody has a right to bail.
Okay.
You only have some exceptions where you may not grant bail. But for a defendant to apply for bail is within his constitutional rights. You can't ask a defendant not to apply for bail. If he applies for bail and he provides reasonable reasons why he should be granted bail,
and the bail conditions is at the discretion of the judge.
Of the judge, yes.
Okay, so that's where I'm coming to.
The bails are at the discretion of the judge. If the judge is satisfied that, yes, okay, this man will not impede this trial if he's outside incarceration, if he's coming from his house, if he's let back into the society, is there a way that such acts might impede the current trial that he's facing before that particular court? Now, that is what the judge has to answer. You and I don't have to answer that.
Yeah.
Because the prosecution's position is, no, we are now granting bail. We want this person to be in prison. Because why? The person may have so reason to not be around for his trial, and then the defense counsel is the one applying for bail and saying, no, this man will always be ready and available to stand trial, even coming from home. He does not need to be incarcerated. Now, that argument comes before the judge. We both make our pleas, we both make our arguments, we both bring material facts before the court that, look, this is my evidence that, okay, this man is entitled to bail because, one, he has a family. He has a family of maybe 6. He's the breadwinner of the family. He's taking care of his grandma at home and all that. And then the judge, after looking at arguments of both parties, and whatever both parties are presented before him or her as a judge, the judge then have to balance it and see, if I grant this person bail, will it be detrimental to the entire case? That's the whole essence of bail. What the essence of bail is for the defendant to be able to stand trial. That is the whole essence of bail. He does not need to be in incarceration to stand his trial. And looking at bail also, you also look at the condition of our correctional facilities.
Okay.
It's congested.
Over congested.
I wouldn't want to use the word over.
It is. That's the reality. Yes.
But
and many of the cases that is congesting our correctional centers,
yes,
are some of the cases that are awaiting trial. Some of these cases have never been entertained in our courts. Okay, that's when the question of selective trial comes in. There are trials that have been forgotten. There are politicians who were indicted and the trials have been abandoned.
Okay.
And there are some of the opinion, when I talk about public perception,
yes,
that some of the forgotten cases, the politicians today, they are in the ruling party.
Okay.
And some of the people that are being tried and bringing to court these days are those that are not, dancing to the tune of the party of the day.
Yes, I can agree with you that so many, the public, like a large majority of the public, also agree with your view.
It is not my view, it is a public perception.
The public perception of selective trials. But then that's what I said. When does the trial begin? So when the case is before the court, that is when the trial begins.
But this
now, selective trials by who? Are you talking about the prosecution agency selecting these trials, or are you talking about the judge selecting these trials?
Yes, complacency between the prosecution agencies, the judiciary, have been accused by the public opinion, that the judiciary is dancing to the tune of the executive.
I think one thing the public should know is this. The wheel of justice never stops turning. It never stops turning. It might be slow, but it never stops turning. Justice will one day be served. regardless of who the defendant might be. Now, when you are investigating a particular individual, going by our prosecuting agencies, and after their investigative activities and a charge is being brought, they feel like, oh, the evidence that we have. Remember, this is the first and most important thing, and I want the public to also know this, because they have to first sit down and look, have we gathered enough evidence to try this man to court, to take this man to court? Does he have a question to answer when we get to court? Now, they have to deal with that first. And if they don't have enough evidence, what do? They go and gather more and investigate. And if the person is not culpable as per their investigation activities, then they make their decision. And if the person is culpable, they also make their decision and charge the person to court. Now, that is the first step. That is from the prosecuting agencies. Now, when you now charge the person to court, you have now brought in the judiciary because the case is now before the court.
Okay.
The charge is before a particular judge. The case comes up. Like I said, the complacency that the public thinks exists between our prosecuting agencies and the judiciary might just be a misconception of, and I think I wouldn't call it I wouldn't even call it misconception. I'll call it the ignorance, because the law is different from the way the public sees it. It's different. Now, the public expects a prosecuting trial to be like sitting in the village market square under the mango tree, where a alleged thief is brought. He stole yam. You bring the yam and keep it. Yeah, I saw him when he was carrying the yam. Yes, you carried yam. And then judgment he's being sentenced there. He's being found guilty, sentenced there, and then the punishment is being carried out in less than an hour. That is not how the courtrooms work. That is not how the law works. The law is so different from there.
Okay, but there is this saying that says that justice should not only be
justice is not a one-way street.
Yeah. Justice is not just to be served; it's also to be seen to be served by the people who, the public. I mean,
yes.
Yeah, it's also part of it. We also have to have that feeling that justice seems to be served in some cases, like the cases I've mentioned that are assumed forgotten.
Yes.
Even if it takes long.
Yes.
But there should be continuation of trial.
Yes.
But some of these cases, the least we have heard is there is no any adjournment or any date for continuous trial in some of these cases.
Okay.
And some of them are occupying position in the Senate. Some of them are occupying political appointments. Some of them are even warming up for the next general elections. So that's the public perception that I talked about. That justice is not seen to be served. You might think justice is being served, but another part of it, another leg is justice must, be seen to be served. So, but the public perception is that public is not seen to be served because the will of justice and the symbol of justice is it is a scale.
Yes.
They ought to be balanced.
Yes.
That balance is what seems to be missing.
What the public don't seem to see.
Yes.
Okay. One thing the public should know is when it comes to criminal trials of alleged crime and persons, it is not something you wrap up in 2 hours. It is not. Like I said earlier, there are protocols, there are procedures, and there are necessary steps that needs to be taken.
Okay, so do you think we need special courts to try corruption and some selected criminal trials?
I do not believe we need special courts because our courts are being created by the Constitution, current courts that we have. From the apex court, the Supreme Court, to the Court of Appeal, to the Federal High Court, to the High Court, and all other courts in the country.
Like we have the Electoral Tribunal. Do you think we need a special court for criminal trial, corruption trial?
No, I do. I don't think we do. I don't think we do because if you're talking about special court, you're talking about or amendments of the Constitution to create those special courts. Okay. You understand? You are talking about...
yeah, because you keep saying you need time. The justice might be delayed because the judge cannot sit because it's not feeling fine. They might have reasons. But don't you think if we have special... Because some are of the opinion that we should have specialized courts, because in some cases, in the Federal High Court, for example,
yes,
and even in the FCT High Court,
yes,
there are judges they have tagged EFCC case judges. They have assigned cases. This is not assumption.
Yes, I know.
They have assigned special judges to special cases, like the EFCC case. You hear some names reoccurring as the justice that is assigned to cases.
Yes.
Like that. So if we can begin to assign special cases to special judges,
yes,
why can't we also have a special court for
I think assigning cases to those judges are because the judiciary, or let me say the CJ, in his wisdom, believes that that particular judge has the capability to handle such cases. You understand? And also, in our judges, they also have ranks. They have rankings. You cannot take a high-profile case before a judge that is just new to the bench.
Okay.
You can't give a baby football to play at the age of 3 months and say, I want you to kick the ball like the way a 10-year-old should play. It does not work. So when the public are saying that there are some special cases assigned to some special judges, yes, because the courts believe in the competency of those judges, that these judges are competent, capable, and will not be intimidated by the media presence that the case tends to, to bring.
Are the courts ever intimidated by cases?
No. The courts are never intimidated. But what I'm saying is high-profile cases like this, there are some judges that, yes, they are ready to stand
their ground,
irrespective of who is standing before them. High-profile cases comes with a lot of pressure, not just from the public. The prosecution are also undergoing pressure. The defense counsel is also undergoing pressure. Pressure to what? To defend his counsel, his client, to the best of his ability. The prosecution is under pressure to do what? To ensure that justice is served. Justice is done. Now, the court is under pressure to do what? Because in the court of law, we have this saying that justice is not just a one-way street. It's not just for the prosecution. Justice is for both the defendant and also for the entire public. Now, that is the responsibility of the court, to make sure that justice is not just done or seen to be done in the eyes of the prosecution or the defense counsel only, but also in the eyes of the public. Now, when the public say that they don't see that justice is being done, most of them, I've heard some of them say, once they grant them bail, that is the end of the entire matter. Bail is a constitutional matter. It is a constitutional right. It is a constitutional gift that is given to every individual.
Until proven guilty.
You are innocent until proven guilty. Because you cannot just stumble into my establishment or place of residence and arrest me, take me before a judge, and then sentence me in a couple of hours. Because why? The law says that I am still innocent. Yes, you can bring all the evidences that you allege to have, but then, even at that point of bringing all those evidences, according to the law, I am still seen to be innocent until proven guilty. It is when you are now proven guilty by the court, now not by the prosecution, not by the public, by the court, by reason of evidences that are brought before the court, that the court says, no, this man, I find you guilty, you did this, you are convicted, and you are sentenced to so number of years. Now, it may be delayed. It takes a longer process, I agree. And the justice system is not perfect. We are far from perfect. But it does not mean it's not working.
Okay.
It does not mean it's not working. We may be far from perfect. But every justice system in the entire world, nobody is perfect. We are trying. Okay? The prosecution are putting in good effort. The counsels are putting in good effort. The judiciary, the courts themselves are putting in good effort. But there are some key factors that might delay the cases. Just some 1 or 2 factors. Like, okay, for every year now, the judiciary go on vacation. Do you know that?
I know. Between September and...
Now, during that vacation period, do you know there are also constituted vacation judges?
Okay.
So that the reason why those vacation judges are being constituted is so that there will be no judge that will not be sitting for the entire period of the vacation, okay, just in case an emergency comes. Imagine if my client was being arrested during the vacation period and there's no judge for me to, but then there's a vacation judge. That is the reason why that judge is there for matters that are pending during that vacation period. Now imagine if there are no vacation judges and then whatever crime and whatever charges are being filed within that vacation period is now being brought when those judges come back. You know how cumbersome that will be. I don't know if you understand me. Now that is the factor. There's the vacation period. A judge can be sick. A witness, even the defender can be, the prosecution that is trying to get justice done can be sick. An event can come up in a day. I've been in court where a colleague of mine that I was appearing with in court was on his way to court and he was involved in an accident on his way to court. What do you expect that lawyer to do? To carry his blood-stained robes and rush into the court because he wants to defend his client?
Cases. The cases we are looking at in question are some of these cases that none of these happened.
Do you think that all these factors I called are only related to particular cases? I'm talking in general.
Yeah, in general. But what we say that even when things like that happen, there should be an alternative arrangement. A lawyer can be replaced, for example.
Yes.
And a trial can be adjourned.
Okay.
But some of these trials that are never adjourned, and the list we've heard of this trial is we don't have any dates for continuous trial of some of these.
Continuation of trial
in some of these cases. So that is what raises the public perception about the selective trial that I talked about.
Okay.
So in your parting shot, because we're gradually winding down now,
okay,
on the program.
Yes.
What do you think this judiciary sector?
Yes.
Because it's an arm of government that that we call the last hope of the
common man. Yes.
And the checks and balances that exist in these three arms of government, talking about the judiciary, the executive, and the legislature,
yes,
seems not to be very active in terms of people just feel that okay, when people want to render you hopeless, they say go to court. It becomes like a slang in our political space today that somebody can just steal a mandate and tell you to go to court. Somebody can slap you and tell you to go to court. What that means is ridiculing that arm of government that once you go to court, if you have your brother as the judge, or if you have your political ally in government, then the case is going to die. Okay,
I agree with you. And I want to believe that is one perspective, because what about those that the courts have worked for? Those that have had matters in court, that have been entertained in court, and they've gotten justice in court.
Yes, but if you juxtapose that with those numerous cases of big corruption cases that we talked about, we might want to think that those that have gotten justice, it does not balance up with
the scale.
The scale does not balance, which is the symbol of justice that we talked about.
No, I agree with you. When it comes to high-profile cases, there are so many factors involved. There are so many things that might be in play that you and I might not know. There are so many. Okay, the two persons that were charged alongside Kyari, the ones that pleaded guilty, that's the one pending before Honorable Justice Iwite. The ones that pleaded guilty and were sentenced to 2 years. Do you know there was a plea bargain in that particular case? Okay. There was a plea bargain.
Yeah. That's another question. The issue of plea bargain. Somebody commits a crime of 200 billion or even a trillion. I'm not talking about these people in question. I'm just giving a general example. Okay. And you are asked to come for a plea bargain of less than a billion, half a billion.
A plea bargain is some sort of agreement between the prosecution and the defendant, witnessed by the court. Now, the defendant comes and says, look, I did this, but please
temper justice
with mercy, and I'm ready to forfeit this, I'm ready to forfeit this. What comes with plea bargain is that remorsefulness that you have as a defendant. One. Secondly, You did not waste the time of the court in lengthy trials
So you are giving
and resources. You understand? You did not take us through the whole calling of witnesses, cross-examination, and all those processes. You admitted that yes, you actually did this wrongdoing. I stole this pen, but please let me replace it with another pen that I have. But then you are not free. You are not an innocent man. You've been convicted, because you will definitely be convicted and you'll be sentenced. Only that because of that remorsefulness, that's genuine act of I am sorry. As a judge or as a human being, if someone that has committed such offense comes and says, I know I've committed it, and genuinely repents, yes, he's definitely going to be convicted. But you are going to, give him a little bit of soft landing. That is plea bargain. It's a bargain.
Okay.
I'm pleading. Yes, I admit I've done this, but I'm pleading with you, please.
That is when there's enough evidence to...
Yes, there's enough evidence.
Yeah.
Even if there is not, definitely there has to be enough evidence before you charge any particular person to court.
Because that's part of why we have one of the challenges that you have rightly outlined that is responsible on the part of the prosecution agencies not gathering enough evidence before the popular media trial that we are all aware about. All right, I think we can continue this conversation on and on and on. But I have had an exciting moment with you.
Thank you very much.
And I would like to bring you back. Maybe definitely not on this particular case, but we have numerous endless cases that we cannot exhaust even in 1 year on this program.
Yes.
But quickly before we go, in your parting shots, how would you assess this, current administration in the fight against corruption?
Well, the current administration, we've seen high-profile individuals being charged to court. Currently, we have the Malami case, where he was not granted bail. Bail was denied, and he was incarcerated, and he was charged to court. So I believe the administration has a goal of bringing erring individuals to justice, just like other administrations might have done. Their way of going around it might not be pleasing to the public eye, but I think the administration is not ready to just sit and allow politicians or erring individuals of the society, no matter how big your status might be in the society, allow them go unpunished. I don't think the administration will want to do that, because it would be a huge slap on the face of the administration.
Do you think they are being selective?
Do I think the administration are being selective? Well, I am not in the Justice Department, neither am I working in the Ministry of Justice, so I wouldn't know. But my thoughts actually is not what actually matters. It's not important, because
it is important to us at this point.
Okay, are they being selective? I don't think so. I don't want to believe so, that they are being selective. I do not want to believe so.
All right. Thank you so much, Sunday Iyanu Opola.
Thank you so very much.
A legal practitioner who has joined me on the program today, Code Files on Third Eye Africa TV. If you have followed us from the conversation from the beginning of this program, you will agree with me that it has been very educating, incisive, and entertaining as well. In terms of the insights we have gained from the perspective of the legal experts we have on the program today as our guest, in the person of Sunday Iyanu Opola.
Thank you very much, sir.
Legal practitioner. I must thank you for finding time to join me on the program today, and I want to sincerely appeal to you that subsequently would like to bring you back on this show to possibly take a look at some other cases we have pending unresolved in the courts today. And that is where we'll be drawing the curtain of the program today, talking about Code Files on Third Eye Africa TV, your #1 crime watch channel in Africa. And we have examined the particular case today involving the former head of the IRT, Intelligent Response Squad of the police. We're talking about Kyari, and of course also try to take a look at some other big cases that are assumed to have been forgotten. According to my learned friend, no case is forgotten. They can drag for as long as long as possible, but justice will certainly be served. And we are keeping an eye on that case involving Abba Kyari, and keep watching this program on Third Eye Africa TV, and we'll keep you updated as the case progresses in the court. And that is where I'll be calling it a day today on the program. My name remains Charles Agedo. From here, I say keep watching this program, same time, same station, and we'll come your way again next time.